Hi everybody, my name is Dave Krupski. I am part of the appellate team here at the Guardian Ad Litem program. Who is also part of the appellate team. Talking about residential treatments on Cinco de Mayo.
But we actually, I was a trial attorney for a few years. Unfortunately, I had a number of kids who were in this setting before, during, after, one of the reasons why I'm glad Dave is here is to help provide a different perspective, because unfortunately, if you've had any of these cases, the kids that you advocate for will never leave you, in the sense that I'm going to remember some of these situations and circumstances the rest of my life. And so Dave is going to be able to provide a different perspective than I am, because if you have advocated for these kids, you get attached to them. You want the best for them, but you also know it can be quite difficult at the same time. So we're going to provide two separate perspectives, but just to clarify, as you can see, if you look at the handout, we're not going to get through 116 slides, because otherwise...
Every single one.
Otherwise, both of us would just be talking nonstop, and that's not going to be...
Well, it's Friday morning too, so if you guys have any questions throughout the process, just shout it out. I mean, let's just be... and we'll go hopefully have a little bit of fun. So, go ahead.
So essentially, the reason why I started or at least I phrased the title of this, clicker decides not to work.
That's like my whole job here too, just push this button. I'm not even good at that.
I know what the next couple slides say, but the reason why it's called No Time to Waste is that unfortunately I would see circumstances where attorneys, guardian ad litems, case management would look at a child being placed in residential treatment as a time to take a break. And it's not because they didn't care about the child, it's not because they didn't want the best for them, it's because the kids who are in these circumstances are very difficult to provide the services they need to become the best child they can be. And so even just myself as a trial attorney, I looked at it as, thank God, it's 4 to 6 months where I don't have to worry about where this child is sleeping at night. And that's obviously functioning at the lowest common denominator, but the kids who have to go into residential treatment have a lot of issues and take a lot of time, and if you have a caseload, they can take a lot of time relative to your other kids. And so sometimes it was nice just to realize that you don't have to check the missing child alert, you don't have to worry about seeing this child on the news, because they at least were in a place you knew that they were safe. But even so, I learned very quickly that if residential treatment was going to be meaningful for this child, it required more than me just sitting back and, so to speak, letting the providers do what they're supposed to do for the child. And part of that, and as you'll find out, is this is a very intricate process, and it involves a lot of different players. We have lots of different responsibilities, and the players aren't always talking to each other, and they don't always know what each other is supposed to do. So if the process is going to be meaningful, part of the reason why we're doing this at all is so everybody knows what everybody else should be doing, or in the case of providers or case management, they're required to do either by law or their own rules. Also, if you had any kids in this situation, the process is in flux. Even myself, one of the things that changed after I was a trial attorney is that ACA used to be like the main driver in terms of finding the provider, in terms of making sure that the evaluators were doing what they were supposed to. And recently that's changed over to DCF to be handling those circumstances. And one of the things that I had an attorney ad litem bring this to my attention is you have to make sure that shift doesn't change how each agency and how each entity is going to view their relative roles, because it was one of the things, it was having ACA the qualified evaluators is you didn't have to worry about, at least they had some independence from the day-to-day operation of child welfare, whereas with DCF, well, almost every person I've worked with at DCF is well-intentioned. They have different competing institutional pressures, and we have to make sure that that doesn't affect the services that are provided to these children. And this is one of the things that I know, as if you're practicing in child welfare there right now, the DCF is in flux in writing and consolidating and clarifying their different procedures. So some of what we may talk about in terms of the actual procedures themselves may get modified over time, and one of the provisions of the administrative code that we'll talk about in the presentation actually was just finalized a month or two ago. So this is changing, and so I'm going to present we're going to present the information to the best extent we can at the moment, but realize at least some of the behind the scenes rules and regulations are changing. So, but we'll show you where to look for those changes. Okay, the key terms, as you'll be able to see, there's lots of them. This is more of a FYI. As you'll notice, getting involved in this process, as in any other field in child welfare, there are lots of acronyms. There are lots of phrases, lots of lingo that you have to know to even meaningfully talk to each other. And what we try to do is just to put a good number of these in one place. The one, most of these will come from the statute or Florida Administrative Code, or in some cases from DCF policies and procedures. But a lot of them, there's a lot of requirements that are associated with each one of these things that in practice you won't necessarily get into, you won't necessarily worry about each particular segment. These are some of the criteria for a child that is diagnosed with the emotional disturbance or serious emotional disturbance. Those are, if you're familiar with the DSM, they provide some type of, if you get bored, you can read more about this. It's going to be a lot of technical language, but ultimately it's going to be the evaluator who's going to determine whether the child actually has this. But in terms of the actual residential treatment center itself, if you've ever gone and looked at one of these, and actually, I encourage you to look and see placed at. And one of the links that I put in there is ACA still has a supervisory role over these facilities, and I put the link to find out where all of the facilities are. So you can find out where they are, and actually you'll be able to look up all the reports and potential violations or licensing issues about each facility to actually give context to what your children are in. But that's what the statute and Florida Administrative Code also says. As you can see at the bottom, the simpler description for a residential treatment center, it's a lockdown facility that provides 24-hour inpatient care in a structured environment. And I encourage you to actually see what that looks like. And there's, like I said, there's all these other acronyms. It's also quite confusing is getting into kids who are in residential treatment is there'll be multiple things or multiple acronyms or terms that will refer to the same thing. If you went to Mr. Anino's presentation yesterday, what he called residential treatment centers was a SIP, and it's a statewide inpatient psychiatric program, and they're really talking about the same thing. It just depends on the context of talking about them in. If you're looking from a Florida-specific perspective, we usually call them residential treatment centers. However, when talking about things like payment or Medicaid or other type of funding, they'll often be referred to as a SIP. So if that confuses you, we ran into the same issue. It's just, as we all know, not every state, not every agency will call what they're working with the same thing, but in this instance it is the same. How many people have been involved in MDT staffing? Oh, good. Okay. Were all those people there? Yeah, I imagine the answer is no. And part of the reason why the answer is no is not everybody who is on that list was supposed to be, knew they were supposed to be there or should be there. I found that out very quickly myself, in that I had to push, so to speak, my way into, I wanted to know what was going on, and that required getting to know when these staffings were held, who led them, how often they happened, how I could participate, and why. And this is, it can be kind of difficult. So one of the practice tips that we'll go over is to interject yourself into the process, because as everybody in child welfare knows, we all have lots of things to do, and we're not necessarily sitting around waiting for other people to join in the process. So this definition comes from one of the department's operating procedures. Again, this will be in flux. But honestly, that's what the MDT is supposed to look like. It's supposed to have people in the service provision. It's supposed to have people who are caring for the child. And also, it's supposed to have GALs. It's supposed to have parents. And although it's not listed on there, in some of these cases, you really need to have attorneys there. And that's not to complicate the process. It's to help make sure that we're not operating on two rails. Too often, I would find that placement and my GAL and case management would be wanting to do one thing in terms of the child's best interest, but in terms of making that legally happen, that could run into some issues about how do we accomplish that. So I would want to be there to make sure that we're synthesizing and working our efforts together to make sure that we can all be on the same page for the child's welfare. Okay. This is one of the new definitions, Florida Administrative Code 65C 27. This is part of the area that's recently getting amended. I mean, to have a child qualify for suitability, I mean, it's statutory. However, part of what the administrative code does, if you've ever decided to get really bored and read through a lot of legalese, is it tries to make things clear and to bring things together that the statute or the rules don't necessarily flesh out, as this is trying to indicate. But in this instance, it actually refers back to the statute, so you're going to have to look at it anyways. But these are examples. How many of you have actually encountered a behavioral health care coordinator? Probably haven't. It used to be called a single point of access. And so that may be familiar, but DCF's changing the names to everybody. So this essentially is the new name for a single point of access. A single point of access, or behavioral health coordinator, care coordinator, is essentially the designated CBC person who is responsible for making sure that the right parties get together to facilitate deciding whether a child is to be placed in residential treatment or not. And because I was involved in the process, I got to know our single point of access very well at the time, who now has changed roles, but that took some time and some effort to make sure that we are all talking to one another. But obviously the first thing is you have to know who's responsible for what, and this just changed. So if you see this, you may want to ask in your local CBC who plays this role, because as we'll talk a little more, is they have very specific responsibilities under the administrative code that you need to know who's doing them. So, okay. These are the qualified evaluators, the entity that is primarily responsible for finding them. I mean, ACA has the responsibility for registering the qualified evaluators. A lot of them have come from an entity called Magellan. It's a private agency. They can be kind of difficult to work with because they're spread out all over the place. I often had evaluators working with my kids who had an evaluation one day in Tallahassee, whereas I was in the Panhandle, and the next day they'd be in Orlando. So trying to coordinate things could be quite difficult. But as you'll see, there are already changes as to how these things are being refined and defined as to who's responsible for what. Okay. This is the legal authority to know, but to make everybody's lives easier, I didn't just say, look that up and go home. What we tried to do was to put all of this information in one place. That way you don't have to go searching through all of these, because it does take an extensive period of time, and admittedly, I had to have some help myself just to know where to look in the first place, and that required some efforts as well. So we've tried to make your job easier by putting this information in one place.
And now there's only 100 slides left. Making progress.
Okay, this is the overview of the process. The reason why I gave the acronyms at the beginning is so you can understand what I'm talking about, but admittedly, this is also to make sure the slides weren't 10 pages long. Okay, the way the process starts, you have a staffing that recommends pursuing suitability assessment for the child. DCF will file, essentially, its notice with the court that they're going to seek residential treatment. They're going to get a qualified evaluator to conduct the assessment. The court must appoint a GAL and attorney if one's not already appointed. In my cases, there was almost always a GAL appointed. However, there was not an attorney appointed. So this was something which we'll talk about when we get to the practice tips. That's something you need to make sure gets done very quickly so that they can meaningfully participate in the process as well. Otherwise, litigation of the actual request can be more difficult than it really needs to be. The GAL and child's attorney must have an opportunity to talk to the qualified evaluator. What I found very quickly, this goes back to how the evaluators are, because they're literally all over the place, that didn't always happen. Unfortunately, my GALs did not always have the opportunity to talk to the qualified evaluator. The qualified evaluator would say, I don't even know who the GALs, or I don't know who the attorney is. And so that would make their assessment incomplete to an extent, not willingly, but because they just didn't have all the information from people who know the child. One of the GALs that I worked with most extensively, she had multiple kids in residential treatment, and she had known some of these kids for 5, 6, 7 years, and we couldn't always get her to connect with the qualified evaluator because they didn't know who each other was. And so that takes some time and effort and some coordination on the part of the attorneys, the GAL, and case management. Okay, this qualified evaluator will file a completed suitability assessment. And I've never seen this happen, although it's there. If for some reason the suitability assessment does recommend an immediate placement, i.e. it cannot wait, it's almost like a Baker Act situation, the rule does provide for that to happen unless the court orders otherwise, because ultimately the court's going to be in control over this. Also, the GAL has the responsibility to file a written report where we have to make our recommendation, and especially before we always had attorneys who were appointed to these kids. We had to let everyone know what the child's wishes were, so that obviously requires meeting with the child in these circumstances. And the way the report really, the standard statewide template that we have, it can be modified to fit this criteria, because really those are the only two things that you have to have in there is what's our recommendation, what does the child want. Okay, DCF files a motion, serves it on all parties and participants. I emphasize that last part because I know a lot of participants that don't always get that. So they need to have it according to the rule within 48 hours, excluding weekends and holidays. The court must conduct a status hearing on the motion. That was often, in my circumstances, it was done in the judge's chambers because it was just something we had to throw together as quickly as possible. The child has to be aware of the hearing, and they have to be able to participate if they would like. And the rule, and as some of the case law, as we'll go through, is very important on the child's participation at all aspects of the process unless the court finds it's in the child's best interest not to do so. Also, the child's attorney has to be there. And a slight modification that was recently made, the child's GAL may be excused for good cause, but really I can't see outside of the GAL not being aware at all or no way possible to get there. The GAL really needs to be there. I've never seen a circumstance where I or my volunteer or the CAM weren't there, because we're involved with these cases just as much as everybody else. If any party objects, you have a full evidentiary hearing on the motion, and I emphasize full evidentiary hearing because the reason why some of these cases exist is because there were not full evidentiary hearings, and that creates problems for the child's due process rights, because those matter just as much as a parent's do. Hold on, go back one. Yeah, okay, sorry. If no party objects, the court can place immediately, and sometimes that happens. I've had cases where a child did not object. They realized that they needed help, and so we placed the child immediately. But that was not always the case. Okay, some of the foundational principles, I'm not going to read these long quotes to you, but this is case law from the Supreme Court, the Florida Supreme Court, and the Florida District Courts of Appeal that talk about what is supposed to underlie this process. In Parnham versus JR, the U.S. Supreme Court said the child has a substantial liberty interest, not being confined unnecessarily like an adult. So that's something that's important, and part of the reason why I think children have attorneys and GALs is to make sure that that's protected. Okay. Also, in MW versus Davis, the judicial system has to recognize the individuality and dignity of the children. And this last part is what's really critical for me, is that the child is not here in the dependency process because of anything they did themselves. They're there because their parents and caregivers failed to protect them and to put them first. And so we have to remember, this isn't a problem child. This is a child who is in these circumstances because other people have failed this child. So this process should not complicate that.
And now you're in a situation where the child's liberty is being taken away as well. So I think that this case really, I mean, if you take nothing away from this presentation, it's really that these kids aren't there by, like Matt said, it's no one's fault. It's their parents' fault. It's not theirs, and they're at a crucial time in their life right now. And it's really just treat them with as much dignity and respect as possible throughout the entire process.
Absolutely, and that can be difficult sometimes because some of the kids, and I'm not saying that because they don't, they deserve to be respected, but some of the kids in residential treatment, they've cursed at their GAL, they have spit, they have done other things with bodily fluids that I don't want to speak of, but that doesn't mean they lose their dignity. That doesn't mean they don't deserve people caring about them, because they are still children. Okay, again, just reiterated this when the Supreme Court approved the juvenile rules related to it. As that last segment is really important, is the child really needs to know that someone else is there fighting for them. The problem in the MW versus Davis case is a child was getting locked up and it was against his wishes, and he didn't feel like he had anybody speaking on his behalf. And so we have to make sure that at the very least the child has an opportunity to be heard.
Anyone have any questions at this point so far? Yeah.
Once the decision, the recommendation is made, if there's multiple possible treatment placements available, residential centers available, can we steer it? And does the court have the authority to steer this child towards a certain kind or placement?
Yes and no. And the reason why I say that is the court has the ultimate authority to put conditions on placements, and however, there are practical aspects that are difficult to navigate. And one of the things that you'll run into is we don't have any options. The reason why I put that, I gave that link to the ACA list of facilities is so you know what some of the other options are. In my experience, What it took was in our MDT staffing, some of this was what we talked about. So we would try to hash that out ahead of time. But ultimately, you would present it to the court, and the court has to make a decision as to what type of needs that the child has. So I'll give you an example. In one of my cases, I had a child who had intense medical needs as well as behavioral needs, and most facilities in Florida wouldn't take that child, and so we had to fight to make sure that he was in a facility that had all of his needs met. That required having the CBC look at out-of-state facilities. So that's ultimately, you just have to make sure that the court is aware of whether the proposed facilities will meet the child's needs. However, the court doesn't have the specific authority to say, I want them in X facility. But the court, and I know Jennifer is a trial attorney, I'm happy to send additional authority related to that. Because that is the difficult issue that we run into over and over again. But in this case, we sent you, the presentation has a list of what the facilities are, but to make sure that they're going to the right type of facility, that requires having the court have the information to know what needs the child's needs are so that they can tailor their orders accordingly. But that was a very good question and very difficult one that we face on a daily basis. Okay, this is what the motion must contain. As well, I know that CLS has a standard template for this, so there's no reason this stuff shouldn't be in there, but just in case you need to know what's in there, that's what it's supposed to have. Okay. Persons to be present or appear at the hearing. I put citations next to each one of these because rarely did we have a hearing with all these people there. Part of that's because of how quickly we had to arrange the hearing, but you need to have all of these people there for different reasons. CLS, obviously, because they're the ones, they're the people who are filing the motion. The caseworker, technically, they're participants, so theoretically, they may not have to be there, but it doesn't make any sense to have this there because case management, as obvious, is behind the scenes one of the biggest drivers as to where the child is going to be placed. You have to have the child and the child's attorney there. You have to have the GAL attorney there. And while unfortunately, I rarely saw this. Parents and their attorneys need to be there because, as we'll talk about a little later, parents are just as much a part of this process as anyone else. And often, in some of these cases, the parents were the best chance at permanency for these particular children. So I want them involved in the process, and the law does too because they're parties. Oh, sorry, back up one slide. Also, the reason I put that last one there, the qualified evaluator, they need to be there in some form or fashion, and that didn't always happen, hence the reason why there's that case law on the bottom. The qualified evaluator needs to be there to be able to justify their recommendation to the court, and that's why I said it has to be a true evidentiary hearing. Now, we can make accommodations like phone appearance, but they need to be part of the process. Okay, this is the legal criteria involved in the child's presence. They're supposed to be there just like every other hearing unless it's in their best interest. However, you can tailor their appearance to the child's particular needs. This case that I cited talks about it in particular. One that it said is it's a phone appearance is possible. But the child needs an opportunity to be heard, and one of the things that was done in this particular case is that the hearing would be stopped at multiple points to allow the child to consult with their attorney. That's part of making sure the opportunity to be heard is meaningful. So we need to make sure that happens. And I realize that is a practical difficulty, but again, this is why we laid out the foundational principles at the outset. The whole reason why we're here is to help the child and make sure that the child is heard and gets the services they need, not to rush them off into a facility. Okay, standard of proof. This is important. It's clear and convincing evidence. It's same standard in terms of evidentiary proof as termination. As that case, the second DCA case talks about, it's because it has similar aspects as a Baker Act, and the Baker Act also requires clear and convincing evidence as well. and that's all the more reason why you need to have the qualified evaluator there.
Yeah, there are a lot of analogies actually in this area of law with TPRs as far as just clear and convincing evidence, least restrictive means. And really it's sort of at a foundational level, it's all just about the best interest of the child. So we TPR when it's in the child's best interest. I mean, at its sort of base level, and it's the same thing here. We're taking away a child's liberty, we're locking them up and helping them because it's in their best interest. And so all those same standards just apply through both of them.
Yeah, I mean if you went to the least restrictive means analysis or the presentation, we're taking away some type of substantial liberty interest. We have to make sure that the person who's losing that liberty interest or it's being restricted is accorded with due process.
That's a terrible phrase, by the way, least restrictive means.
Yeah, it's a whole difficult one in this context as well. Also, I cite that case there, hearsay alone is insufficient to meet this standard. That's another reason why the evaluator needs to be there, because you can't just, while the rule does allow the court to consider the evaluator's report, that in and of itself is not enough. No. Okay. And this explains more. I really encourage you to read this case because it really details the evidentiary issues involved and why the evaluator needs to be there. And part of the reason why we how to protect due process is to make sure that the expert or the qualified evaluator specifically is cross-examined. If they're going to be put out as an expert, they have to be cross-examined, they have to be established there has to be an evidentiary foundation for them to be an expert, all of that. And this, it's just absolutely important. I encourage you to read that case to know exactly how that is supposed to work, whereas I know that doesn't always work that way. But that case is also important because the expert testimony doesn't always have to be from the qualified evaluator. Also one thing that is important is because the fact that the rule does allow the consideration of the written report, you don't have to authenticate the written report, but you still have to have the evaluator there. Okay, this right here, subsection A11, lists what the court's decision is going to be based on. Needs to have an independent assessment of the child from DCF, the GAL's recommendation, written findings of the qualified evaluator, and also the child's views regarding placement. That's at a minimum, so the court also can consider other factors as well. And all parties have to be permitted to present evidence and witnesses. And this goes back to what Dave was saying, if the court determines the child is not suitable, they have to be in the least restrictive setting, best suited to meet the child's needs. Ultimately, that's something that has to be worked out, and the court has to have the information to make that decision, but hopefully in a thorough MDT staffing, that's being discussed because the court has this option, and that means that in discussing whether a residential treatment is appropriate, you don't just vet, okay, it's yay or nay on residential treatment. It's what other options will there be if we can't prove our case, so to speak.
And least restrictive means in this context is also, it's temporal as well. So, I mean, just like in the TPR context, when you have a case plan, by statute, the case plan has to be the least amount of time to accomplish its goals, and it's the exact same thing here. We want to treat the kids as quickly as possible, and just so it's least restrictive.
Yes, absolutely. Okay. Here are the litany of post-hearing requirements that we have to have, and I found as a GAL attorney, one of the areas where, to say this nicely, where the ball got dropped is in all of these other post-hearing requirements. The law requires treatment plans, appropriateness reviews, monthly progress reports. Most of these are filed with the court, which we'll talk about a little more specifically, and additional review hearings. But you have to know these requirements to make sure that you're following them. So here's all the citations on them, and it's a lot. If all of them are being followed, you're going to get lots of documents, on this child. And again, because it's a deprivation of the child's liberty, and it's a high and intense service process for the child. So. Okay. This is something to keep in mind, and unfortunately, even as an appellate attorney, I've had to deal with this. This is not a Baker Act placement. This is not, I've got nowhere else to keep the child to run. If that's the case, there are Baker Act facilities, but this is not an emergency placement. This is not to provide secure shelter, and I've had circumstances where someone has said, oh, this is the only way possible. Well, even DCF's policy says you can't do that. So what I've had, an attorney ad litem, I know that handles a lot of these cases, had suggested is if you need a court order to prevent that from happening in the first place, then get it. You shouldn't, because as we just detailed, there's lots of requirements and steps you have to go through before you can even place a child in one of these facilities. But if you have to get the court order, do it. Okay. Also, this is, just to be clear, we're talking about when the child is in DCF's custody. Occasionally, you will have a child in post-reunification supervision, the 6 months or however longer. That child may need residential treatment. We're not talking about those children, because if a parent has been reunified and has full custody of their child, they retain the rights to make that decision on their child's behalf. But if you want more information, go look at that.
I got a question.
Yes.
All my cases, they don't have a placement by the time we have a hearing. It's not, oh, we lost the placement. So is there a time where it is expired? Because I had a case where we waited like literally 3 months before we were able to obtain the appropriate placement for the child after the hearing.
Well, you have to look at what the evaluator's recommendations are, because those, as Dave said, there is a temporal aspect, and you may need some type of reevaluation to make sure that the child is still appropriate for residential treatment. But the process is designed to be lengthy to a certain extent, so it shouldn't be like, oh, this took too long, none of what we just did matters. Because there are practical aspects to this. One of the things, ICPC applies in these cases, and as you've worked with ICPC, that takes forever and a day. So that really, to answer your specific question in your particular case, that needs to be a question for the evaluator in terms of what's best for the child's needs, and you may need to get a reevaluation as to whether that's still appropriate for the child and the child's particular circumstances. Does that answer your question, or is there other pieces I may not have? Okay. Yes, ma'am.
Just part of that. We've had cases, or at least one, where the court denied the placement, the motion, because the department didn't have a placement at that point.
And I don't think the court should do that because it's placement availability doesn't determine whether a child is suitable for residential treatment. I mean, admittedly, these are medical behavioral findings that don't depend on placement. And I've had kids, unfortunately, one of the kids that I had that we had an ICPC on, it took us a few months to get the child placed, but the court made the finding. And unless that there was something else that said the child was no longer appropriate for it, there's no reason you should deny that placement. So I can understand what the court's saying is, well, if you don't have somewhere to place the child, why am I going to do that? But the standard is not available placement. The standard is what services are appropriate for this particular child's needs.
And the department was, if we get a bed and then we don't have the motion, then
Exactly.
then kind of which comes first.
Yes, because you, as DCF doesn't always know what available placements there are at what available time, and because the process is designed to take a little while, you can't just file a motion today and then get the child placed then. You need to have a court order that says the child is supposed to be placed in residential treatment, and as soon as that happens, the child needs to be placed there. Okay. This is, well, because I'm an appellate attorney too, these are a couple things that stood out to me, and admittedly, they are a little confusing. If you read through 39407, there's this little section in there that says, oh, DCF can do this without court approval. Well,
and one of the, even as an appellate attorney, I'm still kind of astounded this is possible. Both the Supreme Court and the first DCA said basically the rule trumps, and that's not normally how legal authority is prioritized. The more technical, I think maybe the first district, they were trying to simplify things, but if you read the Supreme Court opinion that talks about this, they basically say they don't conflict, which is a debatable issue, but if for some reason you have DCF or case management saying, oh, they can do this without court approval, no, you still need court approval outside of the emergency circumstances that I talked about at the beginning. Also, something that's very confusing is this is a voluntary process. I don't think the child would call this a voluntary process, and I think the lockdown facility makes that sometimes hard to believe. The reason why it's called a voluntary process as compared to the Baker Act is the child's custodian, DCF, is trying to place the child in a facility as the child's custodian, just like any other parent would. But if you're trying to commit someone on an involuntary basis, that would also ostensibly also mean the custodian doesn't want that as well. It's the child's needs mandated. Yes, sir?
So, based on what you just said, placing just as a parent would, if a parent is going to place under that section, you slide this back and they need to qualify to value there? There are Florida Administrative Code provisions that speak to that, and some of them, they're not near as involved as our process is. Part of it's because this is, because DCF's doing it, state action is involved. When the parent's doing it, state action's not involved, but unless the parent just has $100,000 or however much it costs to place, there are extensive provisions, and even if they have that money, there are extensive provisions that are built for to DCF's own internal processes for a parent to do that. So I can point you to that direction about what parts of the Florida Administrative Code speak to that. It's a slightly simpler process, but there's still a lot of things to do. It's not like a parent can just say, I want my child in residential treatment, now you state pay for it. So there are still requirements. Okay. These are the key points before. We'll talk about them as quickly as we can. Go to the next one. Okay. The simple point that I want to try to get across is that the child needs to have a guardian ad litem and an attorney as quickly as possible for this to be a meaningful experience for everyone involved and for the court to have the appropriate information to make the decision that they need to make. And also, as you can see, the legal authority requires this. You need to have a GAL beforehand. You need to have an attorney ad litem beforehand. The statute is very clear. It means whenever residential treatment is being considered, the child needs to have an attorney. So in my mind, that means as soon as someone thinks, oh, the child's blown another placement, even before you convene a MDT staffing, you need to go ahead and get the child an attorney and and a guardian ad litem if they don't already have one. One of the things that I put in the packet of materials is a simple motion in order to get that through as quickly as possible. Hopefully everybody has one of those, but just in case, if you need a motion in order to get a child appointed an attorney, I put that in the packet of resources for you to use as quickly as possible. And then also, okay, here's the staffing process. This is, some of this stuff happens behind the scenes, and one of the things that I encourage you to do is each CBC is going to handle this slightly differently as to who is responsible for what, but essentially it's supposed to be the caseworker looks at the child's condition, and if the child has a disturbance that requires residential treatment, then they need to start the process and make a referral for a suitability assessment and staffing. Okay, the reason why I said that the behavioral health care coordinator is important is because that's the new part of the Florida Administrative Code that talks about what they're responsible for in getting this stuff started. Okay, and this is what I said right here. You need to know what your local CBC is doing. The one that I worked with specifically, even in the few years that I was there, the names of the staffing changed, the participants changed, and what was needed to do each staffing changed. And so you need to
ask them, okay, if a child is supposed to be in residential treatment, what are the hoops they have to go through? The CBC that I worked with, they would have multiple levels of staffing before we actually had a multidisciplinary team staffing for residential treatment. Now, if the process is working the way it should, this stuff should still happen pretty often. We would go from tier 1 staffing 1 week, a couple days later, tier 2 staffing maybe a week later because we have to get more people involved. We have the MDT staffing, but that's probably not always the case. So learn and ask what your CBC uses for these things. And then also keep in mind, part of the reason why the CBC will have these requirements is not because they love regulations. I know plenty of people in case management who wish they didn't have all of those things, but they need to make sure it gets paid for. And that's part of why they have to do what they're doing. Okay, the suitability assessment this is what the qualifications for a qualified evaluator are. They need to have, this is all the requirements, so I'm not going to go ahead and read it all to you. One of the things that's important in the administrative code is that the DCF has the ability to pick one that is geographically located close to the child or where the child's placement is. The reason why I pointed that out is because, unfortunately, if you've been doing this long enough, some of the qualified evaluators are better than others. And sometimes I kind of wished we had different ones. Well, they have the ability to do that. And ultimately, if they're not meeting the criteria, you can still bring that to the court's attention. But there's a reason why you keep probably getting some of the same qualified evaluators is because it's designed to get the evaluation as quickly as possible, which requires someone closer. AHCA, the Agency for Healthcare Administration, they register the qualified evaluators. They need to make sure that they conduct a personal examination and assessment of the child and make written findings. Okay. This is part of the new administrative code process. When the referral is made, the behavioral health coordinator needs to basically get appointment info from the qualified evaluator network and to make sure the transportation is arranged and the records are given to the qualified evaluator. Ideally, this is what happens. That didn't always happen in process. And thankfully, one of the now called the behavioral health care coordinator, when she didn't have everything she needed, she would reach out because we were all involved in the process, but that may not always happen. I've looked at other areas where it was woefully incomplete as to what the qualified evaluator had, but this is also part of why you need to know who the behavioral health care coordinator is, so if they don't have something they need, which their own rules say they need to have, you can help facilitate that process. Okay, the qualified evaluator network provider is going to give notice of the scheduled appointment. I underline these things because rarely did you get actual notice within 2 days of the referral receipt and the initial appointment, and the appointment was scheduled to occur within 5 days of the completed referral. I underline these things because this goes back to you need to know who's doing what to make sure that everybody is getting noticed, because too often the suitability assessment has already been completed by the time we knew who the evaluator is. It's not supposed to happen that way. Go back 1 second. Also, okay, you need to have a report given within 8 days. That last little note that's there is important. Don't give the evaluator old records. Don't give them, they need to have current information, and that requires making sure everybody's noticed so they can give current information. Okay, this is the statutory criteria before admission into residential treatment. Emotional disturbance, serious enough to require residential treatment. This next phrase is important, reasonably likely to benefit. That often is a sticking point from the evaluator's perspective, is some of our children's problems may not be amenable to residential treatment. So that's something to be aware of. I've had qualified evaluators say child has emotional disturbance, but I don't think residential treatment's going to help. So that's something you have to be aware of. The child has to have a clinically appropriate explanation, and all available modalities of less restrictive treatment have been considered. I emphasize that word considered. That doesn't mean child is placed in every single, all available treatment modalities. That just means they've been considered and the comparable benefits are not achieved or available. Okay. Copy of the suitability assessment needs to be given to all these people, and this is something that DCF needs to make sure they're taking care of, but statute requires you need to give a copy of it to the person who's financially responsible for this, because they may decide to weigh in, and they need to have the ability to talk to the qualified evaluator. Okay, these are the only options, and for available to a qualified evaluator, their recommended placement in a residential treatment center, in a specialized therapeutic group home, or therapeutic group home, or neither. There's not really nothing else. Okay. If it does not recommend any placement, here are some options. This happened more often than I ever wish it did, but reconvene the multidisciplinary team and discuss appropriate community supports. This is part of, if you didn't discuss alternative options in the first place, you certainly need to do it now. You can request reconsideration. Part of it is qualified evaluator didn't have all the information, or the child's needs have changed. This goes back to one of the ladies' questions. I mean, if you're waiting months to get child's place, this is a perfect example. If the child's health has gotten worse, then you need to make sure that the evaluator has that, because unfortunately, I've had situations with kids who weren't recommended for residential treatment. 2 months later, we're beating down the evaluator's door and say, please take into account this additional information. However, it's not delinquency or conduct issues, and that can be difficult to suss out as what's a behavioral health issue and what's a conduct issue. You have to make sure that you give the evaluator the appropriate information. Now, just because they're having delinquency or conduct issues still doesn't mean they're not necessarily appropriate for residential treatment. I had, unfortunately, an 11-year-old boy who decided to batter every foster parent that he was placed with, and if you're just looking at the surface, you may think this is just a conduct issue. Well, digging a little deeper, you realize that there are behavioral health issues that are having the consequences manifesting themselves as conduct issues. So that information needs to be presented to the qualified evaluator so they can make the right decision, or, well, I don't want to say right, the appropriate decision given the criteria. Actually, sorry, go back one. Okay. Also, sometimes you may run into some resistance. The CBC may not want to initiate the request. The court can order it. And there are, the court has the ability to order evaluations to make sure that these things are getting done for the child. Okay. This is talking about the court's authority here. This is pretty important. As we went through and going through the rules, if the court can reject the recommendation for residential treatment and order a less restrictive placement. Also, I mean, that's pretty clear. The more complicated question is, can the court order the child placed in residential treatment even if not recommended by a qualified evaluator? Yes. This is a difficult question, however. Okay. This was a memo from, I think, DCF's quality assurance to one of the former state directors of CLS. The court has the authority to place in residential treatment despite a contrary recommendation from the evaluator if the child has the additional protections of the Baker Act. So that's important. Make sure that there are other protections involved as well. And then, sorry. Go ahead.
Has anyone ever actually experienced that in practice? Yeah?
Okay.
Yeah, it's just, okay. It's a pretty rare.
Yes. It's thankfully, before having to go this route, we've got reconsiderations from the evaluators, and eventually we had that. But so legally, it's appropriate.
I mean, basically, it's a judge saying, that I know more than the psychiatrist.
Yeah.
About it.
But the court has the ultimate authority, and they have responsibility to make sure the child is protected. So.
In the situation that I had, the initial evaluator didn't have all the information. So
Yeah. Mhm.
Even with the reconsideration, they still said no. But he was already placed at an STGH placement.
Mhm.
And the therapist that was working with him there indicated he needed a higher level of care.
Yeah.
Although the qualified evaluators continue to say he wouldn't benefit, but he needed it.
And that's a good point. One of the things that we're going to talk about a little further down is there's supposed to be continued evaluations like that to make those assessments. So the qualified evaluator is not the only person who's speaking as to what the child needs. Thank you for bringing that up. The Baker Act, that's Chapter 394, Florida statutes. There is a litany of procedures that you have to go through, and I'm not an expert on the Baker Act, but essentially there are additional protections and standards that are involved to make sure that this is all legal. It moves from a voluntary to an involuntary examination and commitment, and that's an even more severe deprivation of liberty from the child's perspective. And it moves, my understanding is it moves from this is what's medically appropriate or behaviorally appropriate for the child as this is what's needed for the child's needs and the public at large to keep everyone safe. Okay, but look to the, okay. However, here's the bigger issue. You may get a court who's willing to do this, and I've had a court willing to do this. The problem is, who's going to fund it? Because the qualified evaluator's recommendation is important to get the funding. And as another person who presented on similar topics as this said, a court order for placement doesn't determine medical necessity. That's important to make sure that things are getting funded because, as if you probably noticed, you have to meet all the criteria and regulation to make sure that things are getting funded by Medicaid or whatever the child's insurance is to make sure the child's needs. And having a court order say something is not the same thing as having a psychologist or psychiatrist say the child medically needs this. Also, this goes back to something we were talking about a little earlier. The court cannot compel a specific provider to take the child. The court has the authority to order conditions on placements, but not a specific placement. That goes into separation of powers issues, as a court cannot order DCF or another agency to do something that it's not explicitly authorized in statute or some other rule or regulation.
Yeah, go ahead.
Yes. Oh.
Now that ACA is taken over by DCF for those functions, and is there a difference in the qualified evaluators, or is it just that it's in name only, the responsibilities are being taken?
Well, okay, there's not, admittedly, this is still kind of being determined. However, my understanding from speaking with DCF's higher-ups, the qualified evaluators themselves aren't necessarily changing. Magellan is still handling, the entity that is providing these people is not changing. Their supervision from DCF's perspective is changing because, and the reason why I pointed out is DCF is not only asking for the child to be placed into residential treatment, they're also putting the constraints on what the evaluator is doing behind the scenes in terms of following the rules and regulations that they have. So it's not entirely clear, and that's why I said that the process is in flux, because when you had a different entity managing the contractor for all of this, they had their own, ACA had its own rules and regulations that they had to follow as to be a qualified evaluator. But now DCF is also is taking over that role and also controlling some of the funding process. So in some ways it's a name, some ways it's not entirely clear because this shift is happening now. So. Yes, ma'am.
Is an STGH considered a residential placement that requires a court order?
Yes. Yes. And that can be a little, the definitions at the beginning say that specifically, but yes. And if you look at the qualified, well, depending on the form, the qualified evaluator's suitability assessment should say that. But yeah, you have to have that specifically because there are different, and we'll talk about this a little more. There are some things that it has beyond a normal group home. So, okay. These are some options to think outside of the box. Well, wow, we're going pretty long. But the before part is really what the lengthy process is. These are some options to think outside of the box. You want to meet the child's specific needs. Has anybody ever used a CAT team? Okay, so a couple people. This is an issue with funding. Not all areas have this, but DCF got some money, at least previously, to have some pilot projects to have intense outpatient therapy and services for children to avoid getting them in residential treatment. One, because least restrictive alternatives need to be required. Two, residential treatment is extremely expensive. So if your area has this, it's called a community action team specifically. Also, we have APD facilities. I had a child who intersected between agency for personnel, had a developmental disability, but also had behavioral health needs. And so we had to find the right facility that met those child's needs, which may or may not, depending on the facility and their criteria, may or may not require residential treatment order from the court. Also, and I want to be clear on this, when I say delinquency options, I'm not saying I want the child to incur criminal charges or conduct or anything like that. But, as I've already talked about, a lot of these children, unfortunately, also have criminal issues, and you have to bring everybody to the table to see what may work best for this particular child and the child's needs. So this is more, let's get everybody talking, not so much I want child in a DJJ facility unnecessarily. Plus, DCF's policies require this. They need to be talking and coordinating services. Also, medical foster care is an option, but that's more if the child's medical needs are quite extreme. Okay. Also, just to be clear, has anybody had a child in residential treatment placed in a hospital as opposed to a facility? Okay. So there are some, and that's not in my area. Children weren't placed in a hospital; they were placed in specific residential treatment facilities. Most of what we've been talking about, and we'll talk about later, deals with the residential treatment facilities. However, those are the legal authority related to a hospital. Specifically, a lot of them overlap. However, just keep in mind that if your child is placed in a hospital specifically, there are different constraints and ultimately some flexibility the hospital has to have because of other needs the hospital is meeting. Okay. Here's a list of differences between residential treatment centers and specialized therapeutic group homes. This goes back to your question about why a suitability assessment is still needed, is that some of these things are more intense than what regular foster homes can do, and so they have to have the authority to be able to take them. One, limited physical restraint is permitted in a normal group home. That really shouldn't be happening. But there's also supposed to be intense therapeutic services that aren't really happening in group homes. Okay, do the homework. One of the things that you'll be amazed is I went and I looked at the facility that the children I advocated for were placed in. You could see their violations. You could see what they weren't doing, and you could see the plans that ACA put them on to make sure that they got back on track. So the URL is at the end of, we have end notes to the presentation. Look that up and look up your specific facility. Okay, I'm sure everybody is not fond of the fact that ICPC is part of our world, but it is, and it can make things difficult. The reason why I put this here is because in regular non-residential treatment cases, ICPC is a long, excruciating process that requires, for it to get even done in the time frames that it's supposed to, everybody's got to be on top of things. So you need to make sure the same standards are adhered to in applying it to residential treatment. That means all of these forms need to be collected as soon as possible. One key distinction between ICPC in this setting and other settings is the other state is not supervising the child. The residential treatment center facility is supervising the child. So you won't necessarily have the same interaction and contact you would if the child was just placed there in a non-residential setting. Okay, yeah, start the process ASAP. From a case management perspective, this is important. But DCF's own policies say that a CBC will not approve or participate in funding of an out-of-state placement unless they get lots of approvals and authority, but it can happen. And I had a child who was looking at placement in Virginia in a facility. This case in particular, the child was placed in a facility in North Carolina. So it can happen, but you just have to realize that if you're looking at out-of-state facilities, DCF has more things they have to do to make sure that they're following their own rules and get it paid for.
All right, now we're halfway through the presentation. 7 minutes left.
Okay, 7 minutes left. Okay. Okay. This is...
There is access to this PowerPoint, right?
Yes, yes.
So-
Everybody should...
yeah.
Okay, it should be on the app. If you don't have it, please, for some reason, our emails are... We're going to post them up here. This is more just a FYI. Keep this in the back of your head as to during. We talked about the reports. We talked about the treatment plans. All this stuff is supposed to happen. But just because a child's in residential treatment doesn't mean all the other child's needs go out the door. So we'll try to go through this. Okay. I gave who's supposed to be at this facilities. There's lots of staff, but you need to know who those staff are to realize who you should be talking to. So this talks to that. We talk about that. Something that's very important, there's supposed to be a detailed record that's kept on the child that has all of this stuff. So especially if you're a guardian ad litem, your order of appointment should give you access to all of this to know exactly what's going on. So the treatment plan by statute has to be developed within 10 days of admission. The GAL should be a part of this process. Also, the foster parents should be a part of the process. So, okay. Also, discharge planning should be beginning really at the front end to know where the child is going to go and to know what the child is going to do afterwards. Okay. Florida Administrative Code has additional things that the treatment plan has to have besides the statutory criteria, and that's essentially to make sure that it's a holistic approach to the care for the child. Okay. This is important. The reason why I underlined it is just because a child is in residential treatment doesn't mean permanency means anything less to those children. So the Florida Administrative Code requires DCF to follow that. That's why I said parents need to be important. They need to be involved in this process because they're often the best hope that we have. And I say hope in the sense that I hope a parent still wants this child even after they've been going through all of these issues. And you do have some parents. I've had one of the most difficult cases that I had, myself and one of the attorney ad litem I worked with on that case, our permanency plan for that child after residential treatment was the parent. And then we thought it was the best that we could do given the circumstances.
Anyone have any questions right now? I mean, we only have about 5 minutes left. So.
Yes, ma'am.
I have a question. We have gotten to it, so here we go. So we have a residential treatment facility in our area that takes children. And one of two things happen. At 6 months, they say the child has improved this much, and so we're going to release them. And 6 months later, we're stuck in the cycle trying to get them back in because this much improvement didn't do much for them. Or at 6 months, they're like, we can't do anything more for this child, even though they haven't improved at all, and we're going to release them.
Well, I've run into that as well, and admittedly, what I would do in those circumstances is hold the facility's feet to the fire because I would be surprised if they followed all the rules that they needed to do that. This, later in the presentation, which unfortunately I'm not going to be able to get to all of this, but there's a lot of criteria that are supposed to be met before a child is discharged, and whether it's appropriate for a child to be discharged, tell them to prove it. Because I'm not going to take their word at it. Yes, ma'am.
How does trauma-informed care fit into all of this? Most of our kids who get referred to residential treatment, it seems like they have never addressed trauma with kids. They've just manipulated medications and used those as chemical restraints.
It's required under Florida Administrative Code. It's required to be part of it. It's supposed to be in the treatment plan. Again, your rules say this. Your licensing says this. Demonstrate it to me that it's actually happened.
Is the qualified evaluator supposed to consider that?
It doesn't specifically say that, but that goes to making sure that the qualified evaluator has all the information on that. I would think the evaluator's not doing their job if they're not taking into account. However, the facilities themselves have to tailor the treatment plan that involves that. Yes, ma'am.
What happens to a child who ages out while in a residential treatment program?
Depends on the context. Admittedly, this is still of a new area as well. In the circumstance that I had with my child that went back to the parent, there was no longer funding in those circumstances.
You're permanently committed to the department and age out in the residential treatment program.
Simple answer is, with a changeover from ACA, I'm not entirely sure. ACA has said in other materials that I'm happy to send you that theoretically these children should still be able to be in those facilities if they're in extended foster care and should still get paid for because the funding under Medicaid for residential treatment actually goes to age 21 as opposed to 18. But that's ACA's position. That may not necessarily be DCF's position, so I'm not entirely sure. But what I would say, advocate for, is DCF still has the responsibility to provide services. The extended foster care statute contemplates children with disabilities and behavioral issues being in extended foster care. So I'd argue that DCF still has this responsibility, and if Medicaid's still willing to pay for it, there should be no excuse.
But that's funding, though. There's also the authority question too. So if the child doesn't want to be in the residential treatment facility once he turns 18, these are quote unquote voluntary.
Yeah, that if the child doesn't want to, then that's more looking at like a Baker Act type of thing. Sometimes you have children that will want to, but if they don't, that's a different kind of problem. May need a guardian, actually. Yes, sir.
Thinking in terms of if we were going to want to close the motion for a set placement,
Yes.
and the initial evaluation is older than 30 days,
Mm-hmm.
is it reasonable to request a reevaluation at that point, even though there hasn't been a hearing? If we think there's a reasonable basis that the child has changed or demonstrated some better behavior, we don't want to go into a hearing with that full evaluation.
Yeah, I think that is that criteria that I put up there. That came from Magellan. That wasn't something I pulled out of the air. That's their own. That was that entity's own rules for reconsidering. So it doesn't say, oh, it's stale after 30 days. It could be the child's behavior changed 5 days later. So if there are significant enough changes, then yes, ask for a reconsideration, and that's what this own entity is saying needs to happen. It doesn't need to be 30 days or not. Yes, sir.
I just want to address the aging out at 18. I had a terrible, terrible case.
Mm-hmm.
Had a kid going to age out at 18. And everybody was terrified that this child being let into the world because of his behaviors. I mean, it's as bad as it gets. But the problem we ran into is the facility wouldn't enforce the law within their facility. They won't call the cops if the child burps on another kid. We were ended up at 17 and a half, having to have staff in directing the facility to call the police when the child took action, which was against DCF policy. But it was the only steps we could take to get the kid safe. I mean, if he got out of the facility at 18, he was going to be a victim.
Was this child a victim of sexual exploitation?
We don't know.
Okay.
He was a youth until he was 14.
Well, wow. That's the reason why I said that is I put in the materials children who have been victims of sexual exploitation. There are other statutory and Florida Administrative Code responsibilities for those particular youth beyond just residential treatment, and they're supposed to address some of what you're talking about. So it may, if the child is mute, I think that's what you said.
Until he was 14.
It may be difficult to get the child to disclose the necessary information to get these, unfortunately, these protections for the child. But children who have been sexually exploited have even further protections in those circumstances. In your particular case, when the child aged out, it probably didn't feel good by...
He did not age out. They did finally call the police on
Okay.
his activities within the facility, and he was brought into the legal system and sent to a competency facility.
Oh, okay. Well, and that's...
As good a consequence
Yeah.
as you could end up with.
Yeah, I agree, because you don't... Because unfortunately, in some of the cases that
I've had, that the kids, they have so many different issues. They be charged criminally with things which they aren't competent as to know what they're doing, and that's all the more important process. In one of my cases, we were in contact with DJJ so they would know what's going on as part of this process. And theoretically, DCF should know all of these things, because in Florida, if you have a juvenile that's incompetent, they're actually committed to DCF and their facilities. So just, you want to get them to know what's going in different parts of their own agency, which can take a big endeavor. Yes, ma'am.
Yeah, the one I had two was aging out, 18 years old. At that time, we were very fearful of the child being, well, now soon being an adult. Said he was walking out. The agency said they wouldn't keep him past age 18. They said they didn't have to. His parent, who had him in custody for years, actually had went and filed for guardianship. So we did get guardianship and all that. The other case we have with the 18-year-old, we knew, I mean, we've had him for years. I always consider those our home babies. They, the same thing, the facility said they don't keep past 18. It was just when EFC, we got the extended foster care, the agency they paid for, I mean, it was an obscene amount of money to get like multiple service providers to come in, because they didn't know what else to do. And eventually though, he did qualify to go to APD home.
Yeah, and in the case that we had, the problem we were dealing with is we didn't have the ability to get a guardianship set up in enough time to get the child in a home like that. But it sounds like you guys did the best that you could given those circumstances, because with some of these kids, they may qualify for an APD home as an adult, and that's the best residential setting that you can get. I'm glad that you guys were able to accomplish that, because that doesn't always work.
Yeah, so we're out of time, but like I said before, look at the PowerPoint. It's a great resource as far as everything just put into one spot. Yeah.
All of this is being filmed, and the PowerPoint and the film will be available on the website.
Great.
It'll take us about 4 weeks to get it up.
Okay. Well, have a great day and weekend, guys.
Our